Welcome, everybody. Just put our cameras on to this CCP conversation on the Google Shopping General Court judgment. It's very good to see so many participants on already. The numbers may tick up a little bit more, but I think we should get going. So I'm going to start with just a very brief introduction, and then I will introduce our panel, and then we will kick off. So as many of you will know, if you've joined us, on the 10th of November 2021, the General Court of the European Union handed down its long-awaited judgment on the Google shopping case. Could everybody have their mic off if they're not right, if they're not on right now? This ruling upheld one of the most controversial and consequential competition law decisions by the European Commission over the last decade, I think. It took 7 years of investigating the case at the European Commission. So the case started in 2020. It started in 2010. The Commission concluded in 2017 that Google had abused its dominant position in violation of Article 102 TFEU. And at the heart of the Commission's finding lay the relatively untested concept of self-preferencing. So that's really what we're going to be focusing on today is self-preferencing. So what was the case? The case was that Google had designed the results page of its well-known, that we all use, Google search engine in a way that favored its own Google shopping box. It had made it prominent on the page. It had also placed rival comparison services at a competitive disadvantage by actively demoting them down its general search results. So that was the finding. So the Commission not only sanctioned Google's conduct by imposing a then record fine of 2.42 billion euros, but it also ordered Google to put an end to the self-preferencing conduct and ensure equal access to all third-party providers on its general search website and to its box. So the case has now had wider ramifications as well. I think the concerns about self-preferencing are now the basis of a wide variety of cases being taken by competition authorities globally. And at the same time, concerns that antitrust is not necessarily the best tool to address these sorts of issues, and indeed other sorts of issues in the digital space, has led to the development of specific ex-ante regulation for digital platforms. In the EU, that's the Digital Markets Act. Elsewhere, there's other things progressing, and these themselves specifically address self-preferencing. So there's a lot going on in this area of self-preferencing. So today's conversation is going to be in three parts. First, we are just going to focus on the basic concept of self-preferencing, what the judgment does and doesn't tell us about when self-preferencing will be abusive. Second, we're going to talk a little bit more about the specifics of this case and the evidence presented by the Commission to demonstrate its case, and what this tells us about the evidential standard expected for an Article 102 self-preferencing case. And third, we're going to consider the implications for digital regulation more widely. So to help consider these questions, we have a great expert panel with us, all of whom are members of the UEA Centre for Competition Policy. Damien Géraudin is the founding partner of the law firm Géraudin Partners, and is also a professor of competition law and economics at Tilburg University and a visiting professor at UEA. He has assisted clients in many high-stake European Commission investigations, but had no involvement in this specific case. I believe he has acted against Google in other cases. Kayuve Kuhn is a professor of economics at UEA and also an academic advisor at Brattle Group. He's served as the chief economist of DG Competition at the European Commission, including during one phase of the Google shopping case. He has a long experience of advising on competition cases, in particular in digital markets. He does advise Google, albeit not in relation to this case. And Elias Deutscher is lecturer in competition law and IP at UEA, and he has a very nice paper on this particular judgment, the Google shopping judgment, coming out soon in the journal European Papers. So that's the panel. So the first topic that we want to talk about is the concept of self-preferencing. So in upholding that Google's practice of self-preferencing amounted to a standalone abuse of dominance, the General Counsel essentially found Article 102 to be arguably a more open-textured and versatile provision than is often suggested. So in particular, there'd been a big debate about whether the essential facilities doctrine derived from the Bronner judgment was required to apply. So the General Court does find that Google's general results page has characteristics akin to those of an essential facility, in as much as there is currently no actual or potential substitute available that would enable it to be replaced in an economically viable manner on the market. But it considered that this did not mean that the conditions set out in Bronner had to be systematically applied. So the judgment essentially confirms that self-preferencing can be an abuse in its own right. Does that mean that self-preferencing is automatically abusive by its very form? Well, that's one of the things we're going to look into, but arguably it would be disproportionate. Millions of firms, including many that may well be dominant, do give a degree of preference to their own services. Most of the time, this isn't going to be anti-competitive, particularly anti-competitive, may even be pro-competitive. So I'm now going to turn to the panel. What panel do we think that we can learn from this decision about what self-preferencing, when it's likely to be a problem legally or economically, and when not? Does the General Court give us anything that really helps provide limiting principles? And what perhaps more should it have said? Elias, maybe I could go to you first.
Yeah, thank you, Amelia. I hope that you can hear me well. And thanks a lot for introducing us as well, and for your kind availability to chair also this panel. So let me start just by very briefly picking up on what you said about what we know after the General Court's judgment. So first of all, self-preferencing, or what the General Court also calls favouring, might constitute a standalone abuse, and the Commission doesn't have to prove the Bronner criteria. And I think that these two clarifications are really important because, first of all, they show the way forward as to the scope of Article 102. So I would suggest that Google Shopping has a similar implication as Deutsche Telekom, for instance, which found that margin squeeze is a standalone abuse under Article 102. And I also think that the fact that Google Shopping is limiting the scope of the Bronner criteria or the Bronner test to express refusal to deal is a major clarification. And I think Damien might also be willing to comment on this, but I think it's also a favorable, or it's a positive development, because to my understanding, Bronner in certain circumstances is too restrictive. So let me turn now to what I think we don't know after the judgment, and I think that's the more critical part of the discussion. So first of all, I think the General Court does not really explain what exactly self-preferencing is or favouring is. So which conduct elements have to be fulfilled for there to be self-preferencing? So the General Court seems to suggest that self-preferencing, in order to fall afoul Article 102, needs to include, on the one hand, upgrading of the dominant firm's own business division, and secondly, downgrading of the visibility, for instance, or the ranking of competing services. And the question is, so in future cases, do we need both conduct elements to be fulfilled for there to be an abuse? So are these cumulative elements or not. And I think that might also be relevant if we look at the DMA. I think the second important drawback of the judgment is that the General Court omits to lay down a clear legal test when self-preferencing then leads to anti-competitive foreclosure, which is unlawful under Article 102. And the General Court seems to oscillate between different potential tests. So on the one hand, it mentions that self-preferencing might constitute anti-competitive leveraging, but it's not very clear what the Commission then has to show. Secondly, as you have mentioned, Amelia, the General Court introduces this notion that Google's general search result page is a quasi-essential facility or has features akin to an essential facility. But to my understanding, this is in open contradiction to the fact that the Bronner criteria do not have to be fulfilled for there to be an abuse. So there's a major tension here. So on the one hand, the General Court says Bronner does not have to be fulfilled. And on the other hand, it seems to suggest that the Commission implicitly at least showed that there is some form of an essential facility here. And then the third way how the General Court seems to try to provide a legal test here is that it suggests that Google's self-preferencing is an abnormality because it amounts to undue, unequal treatment. And to some extent, I think the General Court here relies on the assumption that Google's business model for the general search result page is that it provides unbiased, neutral access to information on the web, and that by granting preferential treatment to its own comparison shopping website, regardless of its relevance, Google's self-preferencing goes against its basic business model. So to some extent, the General Court creates here a non-economic sense test. So it suggests the self-preferencing is going against the business model of Google, and therefore it can only be explained by an exclusionary intent. And I think that is a very strong assumption, which we might also discuss further in the rest of this discussion. Let me finish just by pointing out the broader implications of this judgment. So I think the judgment still shows that there is a considerable disorder, conceptual or analytical disorder in the assessment of abuse of dominance under Article 102. And this arises from the fact that courts and the Commission try to fit new conduct into existing categories without having really a unitary framework to assess exclusionary conduct. And I would suggest, and we might also come back to this, that grounding the assessment of self-preferencing within the raising rivals cost framework might actually provide a better understanding as to what we should look at in order to determine when self-preferencing is unlawful, and also might provide some limiting principles.
Thanks very much, Elias. So you're right that they highlight this kind of upgrading and downgrading point, the quasi-essentiality point, and this abnormality point, that this is just abnormal behavior for something that is designed to provide a fair and open set of results for people searching the web. But are they all of those required for any future cases? Were they required for this case? Damien, what's your views on what we learn about the general approach to self-preferencing from this case?
Yes, thank you very much, Amelia. First of all, I should say that I do believe self-preferencing can be an issue. And, you know, as to the outcome of the Commission investigation, I was not unpleased by the outcome, right? But I think this judgment is not entirely convincing. And it's not entirely convincing, and I will focus on 2 points. I mean, the legal test with respect to self-preferencing, and then this issue of essentiality and whether the Bronner conditions should apply. So when it comes to the, you know, legal test, I mean, first of all, they say that indeed 102 is quite flexible and leveraging can be a form of abuse. Fine, nothing to, disagree with there. But then they say that, well, it's not enough, right? I mean, it's not because you engage in some form of leveraging or self-preferencing that there's necessarily a breach of Article 102. So, second step, you need to show that the leveraging practice has anti-competitive effects. And we will discuss, I think, the effects in the second segment of this event. But then third, they say, well, the leveraging practice must depart from competition on the merits. They use a lot these terms, competition on the merits, actually 44 times in the judgment. I know that because I was asked to make a presentation 2 weeks ago on the concept of competition on the merits. And very often there's a sort of reverse. There's a sort of the more you use the notion of competition on the merits, the least convincing your reasoning is, because it's a vacuous notion, right? In fact, in my analysis of the notion of competition on the merits, which is dealt with at length in the opinion of Advocate General Rentos in NL, you really come to the conclusion that in fact it means nothing. That's why it's such an attractive concept for many, right? It's competition on the merits at the end of the day means good competition. It's an ideal. I mean, that's the sort of competition we want to see prospering, whereas, failure to be in line with competition on the merit means bad competition, the one we don't want to see. Right now, they want to give a bit of substance to this notion of competition on the merit. So what they do is that, first of all, they say that there are specific circumstances in the present case. The fact that, the Google search traffic was important for comparison shopping services. The behavior of users when searching online was another important factor. And then the fact that, the diverted traffic from the Google search engine result page accounted for a large proportion of traffic to these comparison shopping services. But, to some extent, it simply means that in this case, leveraging mattered, right? It was important not to engage in self-preferencing to allow these other companies to compete. And then it wants to add another element to give some texture to this notion of competition on the merits, which is abnormality. And this is not totally new. I mean, if you look at the literature and even the case law on predatory pricing, for example, one will say predatory pricing is abnormal. Why would you price below average variable cost? This is bonkers. You don't want to do that, right? So it's another element that they bring saying, well, it's not competition on the merits because a sort of, reasonable competitor, one that does not want to distort competition, would not do that. But it's not over. Then they bring into the discussion the fact that there is EU legislation imposing on internet access providers a general obligation of equal treatment. And then there's another little bit, which is to say, well, in this case, it follows a change of conduct, right? Initially, this is not what Google did. It only came later, right? And that's another element that suggests that this is not competition on the merit. So, it's not as if you had a very sort of clear legal standard. It's just that, as I was discussing with Cayuve before the court, it seems that the court, the general court has a strong intuition that what Google did is wrong, and then is using various bits and pieces to get to that result, right? The second point I wanted to emphasize relates to, the argument made by Google. Then, at the end of the day, this is a matter of refusal to supply, right? And and to the extent that this is the argument that the Commission, made, it had to show that the Brunner conditions were present, right? And the key element in the Brunner condition is the notion of indispensability, right? Now, what is really quite interesting in this case, it's another illustration where the General Court tries to narrow the scope of Brunner as much as possible, making a distinction between scenarios of outright refusal to supply, I'm not going to supply you, period, and cases where you do supply, but not in the right way, right? I mean, you know, you're supplying under unfavorable conditions. And of course, this is one of these, you know, funny things about competition law, because it means that as a dominant firm, from a legal standpoint, you're in a better position if you strictly refuse to supply than if you supply, but, you know, not in a fair manner, right? And this was discussed. It was at the core of the Slovak telecom judgments of the General Court and the Court of Justice. I was acting for Slovak Telecom in these cases where, you know, basically told both court, look, that's bonkers, right? I mean, you know, in this case, Slovak Telecom is supplying, but it is argued that it is not, I mean, it is supplying under unfavorable conditions. And the commission say, aha, well, in that case, the test is not Brunner, right? And the condition of indispensability, which the commission could not prove, does not apply. You know, but here it's doing exactly the same, where it says, well, you know, it would have been different, it seems, if Google had simply refused to deal with rival competition shopping services. So that's one of the odd thing about the EU case law. So to cut a long story short, whereas, you know, in many ways, I like the outcome of the commission decision and the General Court, I'm not entirely convinced that this is the most coherent and elegant judgment I have seen in recent years.
Thanks. And of course, to some extent, it could be said that a lot comes down to the evidence on effect, which is what we'll be coming on to later. And I guess economists naturally go, well, why do we need all these principles anyway? Can't we just look at look at the effect? So maybe it's a move in that direction to some extent. But sticking for the moment with what we can learn about principles, Kaive, is there anything you'd like to add?
Yeah, I think from an economist's point of view, it is important to use principles, but I think it's principles that go in the direction of having a coherent way of analysis across different types of behaviors. And I think that's one of the things that I think we've always been fighting against, and where I see kind of this as part of even a rollback, is to kind of isolate different behaviors. And they say they're different behaviors, and now we're creating criteria for this behavior, without kind of regard to the fact that different behaviors might have very different, similar effects in terms of what they're doing to the markets, and that you can learn by similarities from how you should be treating behaviors that seem different. And in a sense, we all talk about how self-preferencing is new. I never thought it was new. But the reason why we think it's new is because the law is making this strange difference between price behaviors and behaviors that are affecting the demand side. And that's just wrong. So self-preferencing behavior, we had discussions about on the pricing side, namely if I have an upstream firm that has its own downstream unit and a competitor downstream unit that it supplies, then people were saying you are preferencing yourself, or you're price discriminating against the other guy if you're charging yourself a lower price than you're charging the competitor. We very soon realized that that was, for what we're really interested in, namely foreclosure, neither necessary nor sufficient. And we realized that if we wanted to talk about foreclosure, we would be getting to the margin squeeze test. Now, the really worrying part for me as an economist is then that the result is, and this has come out good in law, that the margin squeeze as such became a self-standing offense. because even that is not really what we're concerned about. We're concerned about, yes, a margin squeeze can lead to foreclosure, but we're interested in anti-competitive foreclosure. That is, if the end consumer prices don't go up because I'm foreclosing an inefficient competitor, for example, we're not so concerned about this. I mean, for example, in the Slovak Telecom case, one thing that made me really worried about the case was that the response to a margin squeeze was building out your own network, right? So there's the question, to what extent are you getting foreclosure? And that's really what you need to deal with in such a case. So if I'm thinking about this type of case, then it's actually not that different because in the price, it's you're raising the price. What you're concerned about is raising the price of the other guy relative to your own price. Here, you're concerned about reducing the quantity of the other relative to your own quantity that you can sell. So it's a quantity restriction instead of a price. So it's a quantity discrimination instead of a price discrimination story. But the question is again, are you achieving foreclosure or not? And I think that's where it then becomes important to ask the question of the competition analysis and really ask, are you getting to foreclosure? And I don't care so much whether we're calling something an essential facility or not, or whether it's a Brunner criteria or not. What we really need to look at is, are we getting foreclosure that these firms are not competing anymore so that somewhere the price is being increased? That element is actually never discussed in the decision, which I'm very upset about because I always emphasized it during the time that I was working with the case. But who would the prices be increased to? And since we're here talking about shopping, it's really the question, to what extent is there competition for stores advertising to end customers? And are those advertising prices increased because there's foreclosure of comparison sites? That's really what one would want to look at if you're thinking about competitive effects. None of that has actually been looked at. None of them has been looked at in the decision. And the problem here is that you actually don't have proper criteria to evaluate whether there's a likely anti-competitive effect. It's not about showing that for sure there was the effect, but that it was likely from the analysis of the market. And that also means that the court is not creating criteria to actually test whether the evidence that was brought forward actually speaks to the competition problem. And that's particularly problematic in these foreclosure cases because typically a behavior that doesn't achieve foreclosure in that sense will actually be pro-competitive, because it's basically meaning you're entering into the market with a product where others are competing. They think that's really terrible that you're entering the market because you're taking market share away from them. But that's the pro-competitive effect. And the interesting thing is that very often behaviors that are not leading to serious foreclosure effect will actually have the opposite effect of being pro-competitive. And I have to say, kind of in the early stages of the case, we were actually still very conscious that there was a real issue that needed to be addressed. Namely, to what extent what we were seeing in Google was an entry into an activity that was an innovation of participating in kind of that shopping stuff in a new way that might have pro-competitive effects, and whether it was legitimate and pro-competitive to actually suppress innovation on Google's site offering new products. And that kind of issue of that trade-off has, I think, completely gone out of the window from kind of reconstructing it to the back, from the back, what might be right, so that the tension of the trade-off doesn't become clear anymore. And once that doesn't become clear anymore, it also becomes completely unclear what you should actually be evaluating. And I think we're going to see that when we're getting to the effects analysis. But I think, I mean, for me, that's really the biggest problem. We're going further and further away from a common common analysis of foreclosure type of issues. We're seeing that in the different treatment of pricing abuses and non-pricing abuses, I think, and we're going to talk, I think, about the contrast to the Intel case later on. But for an economist, I think that is kind of the core issue. We're not creating a legal language in which we can actually evaluate potential trade-off and risks in both directions to competition.
Thanks, Kove. So, I mean, I guess the big points, well, there were lots of very good points made there, but I particularly took away this point that actually it's not clear from what we have read in the judgment how you really distinguish between the pro-competitive benefits of self-preferencing and the anti-competitive benefits. And in looking at anti-competitive foreclosure, there isn't much in the decision that actually then looks at the impact on prices paid. There is, I think, quite a lot on why it's actually anti-competitive, but maybe not why there is foreclosure and why it's anti-competitive foreclosure. But maybe, I think you're right, there is not a lot on the prices. So maybe even in the next section, I'm going to take us on to the next section, but I don't know if Elias or Damien want to respond on those 2 points as part of the next section. But I will take us on. Just to say before I do that I should have said right at the start, we have an hour and a half for this session, but we will try and finish a little early. We don't necessarily need to use the whole part of it, but that time. But what that should do is allow us some time for Q&A at the end. And you should all have access to a button that says Q&A. If you want to put in any questions, you can also then vote. People can upvote and down, well, I don't know if they can downvote, but they can upvote the questions, which means that I will, as chair, then be able to see which are the most popular questions to be asked. So I think you've probably heard enough already to start adding some questions. So please do feel free to do that, and we'll come to them at the end. So just bring them, introduce them as when you wish, but there's actually no hurry immediately. So with that, we're now going to look at the evidence in this particular case. And as you'll probably be aware, I'll just run through what some of the key elements were of evidence in the Commission's case, which were in turn upheld by the General Court. So the first is that Google is an online general search engine with a very, very high share of general online search. Second is that general search provides a key point of entry for shopping searches, such that the traffic generated by Google's general search engine is vital for comparison shopping services. The third is that users typically concentrate on the first few results. So pushing results down search rankings does have a really big effect on traffic. And in that context, and this slightly goes to the point about competition on the merits, the General Court says, even if the results from competing comparison shopping services were more relevant than those provided by Google, they could never, under this system, have received the same treatment as results from Google's comparison shopping service in terms of their positioning or their supply. So there was a lack of equal treatment, which is one of the terms we've already heard. They then find that this lost traffic could not be effectively replaced by other sources of traffic like advertising or mobile applications. And on the basis of all of that, the General Court concludes that the potential outcome, they don't say there has to be an actual outcome, although I think there in fact has been something of an actual outcome, but they say the potential outcome was the disappearance of rival comparison shopping services, less innovation on that market, and less choice for consumers, all characteristic features of a weakening of competition. So I think those are the key bits of evidence, and there is obviously quantitative and qualitative evidence underpinning each of those points in the decision and judgment. So let me now come back to the panel. What do you think of all this? Is all of this really enough to demonstrate both dominance and abuse? Did the Commission and General Court really need to do more? I'm going to ask Kove to come in first this time.
Yeah, thanks, Amelia. I think I can only kind of cover a couple of those points there, but I think one of the problems that I have with the judgment that it really did not test the quality of the evidence in a lot of these cases and took a lot of things at face value. And I think something that's really important here, kind of a first order importance, is the question of how do you actually get to market as a shopping site, or kind of how do people actually do shopping? What are you competing with? How do customers shop, and what role or what are the substitutes for the shopping sites there are, or the shopping or for the Google shopping site? So one of the first questions that one has to ask is one of market definition here. I think what this judgment does in a really worrying way is support something that I know that economists in virtually all agencies are fighting, is a tendency to say, we have a product here, and what are things that look like it? And now I'm listing a couple of characteristics and basically say, this other product has similar characteristics, but there are other products that don't have similar characteristics, therefore they're not substitutes. We know from economics that that's fundamentally wrong, that it's actual substitution that matters. And I think the big problem, one of the big problems I have at the very start here, is that market definition was done in this way here. And a lot of other possibilities of actually searching and looking for products were excluded from the market without there being economic evidence that there are no substitutes for the types of searches that people are doing. And that makes me very uneasy, in particular because there is other evidence, even in the public domain, that suggests that search behavior is much more complex, varied, and much more sophisticated than the simplistic thing is that you always start your search on Google. And if you don't start your search on Google, you're not searching anywhere else. And therefore, the shopping sites have a problem. So if you're looking just kind of a couple of facts on where people are actually getting information from in order to make their choices, so essentially searches, by far up there, 70% are online marketplaces, and then 51% store websites. The next one is search engines with 49%, and then comparative websites are somewhat different. So we have no evidence here and actually on how people are structuring their search history in the decision or question about this. There's kind of this question, it was kind of alleged, well, you know, Amazon is a substitute for people, how people are searching. I actually think that's probably true. I mean, that's now introspective. If I'm taking my introspection and comparing it with that of the court, I'm actually searching a lot more on Amazon, but also on other online stores, just because there's a combination also that I want to know not just what the comparison websites tell me, but also the availability of the products, how fast can they serve me, et cetera, et cetera. So when I come from that position and asking the question of how people actually search, and it's completely feasible to get that information through surveys, I'm kind of getting to the point where I ask myself, is that market definition actually true? And isn't there potentially a reason why comparison sites in some of these areas, especially shopping, have declined? Just because they don't give searching customers the type of information that they actually need. That's something that I want to exclude when I'm kind of looking at what I'm actually seeing in terms of the searching behavior. And so some of the things that I've also seen is, you know, people search on Google, they go onto Amazon, they go back to Google, they go to Coolblue, et cetera, et cetera. And it's very complicated search histories where really the question is, does that actually make sense? I think we have similar issues on the foreclosure issue. And there's actually something I think Elias might have mentioned this, that if we're asking the question, how did the amount of searches that comparison websites got go down because of Google Shopping and its preferential treatment, you have to kind of look at the counterfactual. Now, in the case here, we have kind of a coincidence of an update to the Google search mechanism coming in. It's called the so-called Panda update, because I think the engineer's name was Panda, the last name. And the goal was actually that at the time, and I don't know who remembers that still, but you did Google searches and you got kind of a first result that was essentially an advertising farm. If you clicked on this, I think there were things like 123.com and things like that, where you clicked on it, had no content. It just served your advertising. And so it was very low quality research search results, but it were firms that managed to game the algorithm. So from my understanding, and that also is in the decision, the algorithm was changed to actually downweight search results that did not have original content. Now you might say that a company like Foundem that really as a comparison site virtually just listed different products, they kind of dropped like a stone in that evaluation. Interestingly, and I don't see an evaluation of that in comparison. I see examples that were badly hit, but I never saw mentioned the examples that I found also really important when I was looking at that at the time and finding the search results, like TripAdvisor, that after that update was almost, whenever it came to kind of searches on travel, came up very often first or second in the search. Why was that? Because TripAdvisor had a lot of original content through what the people visiting the sites were doing in terms of reviews. So here really the question is, what happened here? Was this just a byproduct of a Panda update that had a certain goal? Or was it really the goal to downgrade people because you wanted to monopolize shopping? I think that's a question that's not being answered through the evidence that we're getting. Another thing that's kind of not being answered is kind of the question on, you know, what is really the competitive effect, right? This is what we've been talking about. Has a distortionary effect on the outcomes of competition in terms of the advertising on shopping sites? Do we really have a reduction in competition in terms of the experience of end consumers, both in terms of the advertisers or the end consumers are buying the products? I think those are kind of open questions that are not even addressed, or there's no need seen to address that. And I find that relatively disturbing.
Thanks very much. So, I mean, there's a number of, again, very good points in there. I think going to this point about the different ways in which people search, I guess it could be said that you might become a first point of search if you have already built a brand like Amazon has, but that you can only start to build your brand if you can be found on Google, because you have to be found in the first place. So I guess that might be, I agree with you that the judgment doesn't go into it, but you could argue that Google is an absolutely critical first, a place where entrants have to go if they want to win in any custom, even if marketplaces like Amazon maybe don't need it so much. But that's just me throwing in a comment. I
understand that, and I think that was exactly the reason why the case took so long initially, because the problem was, how do you actually define what the foreclosure actually might be? So the question is, you have a complainant like Expedia, and you ask the question, is this really for them an important way to market? if they're advertising almost everywhere. Are you then talking about the tail, but how do you show that that supposed foreclosure in the tail is actually material? We have new companies now like Cool Blue that are websites that are selling loads of stuff. They get #1 placements, for example. And actually, one point that I was forgetting in the last thing that I was doing, of course, you also even have possibilities of being seen on the website in terms of advertising there. That has a cost, but then we're back to a margin squeeze analysis, right? So there's the question, so what's the cost to Google? Well, there is an opportunity cost of actually not advertising someone else because they're getting money for it. But that kind of shows how close that relationship is, right? And so not considering those other ways to market that may be more costly, but where the question is that sufficient to have foreclosure if you have an efficient offering? That is, I think, what the weakness is. I'm fully taking your point, but I think that's exactly the difficulty is where is there the material foreclosure, right? And how to decide that it actually is material.
Okay, so I would say in general, your point is that on this point, at least, that it's oversimplistic, the argument that's been made and more needed to be assessed. Damien, do you want to come in next on this?
I think I'm supposed to be the last one.
Oh, okay.
Yeah.
Elias.
Okay. So let me just address, I think, some of the points that Kai-Uwe makes and also link it to the previous discussion. So I think what is interesting here and what emerges from our discussion is that we can actually put substance on the concept of competition on the merits by asking ourselves, so first of all, does the conduct here, self-preferencing, raise rivals' cost? And secondly, does this lead to foreclosure, partial or total foreclosure? And secondly, is this foreclosure sufficient enough then to have adverse effects on competition in general? And I think on this basis, we can then discuss further the different types of evidence that the Commission took into account. And I think on both of these questions, then one might disagree as to how much the Commission actually has to show under Article 102 to find an abuse. And just to address some of the points with respect to the foreclosure analysis. So I think what the Commission does, and where it's nonetheless, I think the analysis has some merits, is that it looks at the importance of the traffic originating from Google search for the overall traffic that comparison shopping websites obtain. So it looks to some extent at the foreclosure rate, at least of the conduct on the proportion of traffic. And secondly, it also looks at alternative sales channels. So it looks at whether, for instance, at online search advertising, but also the direct channel are sufficiently effective alternative sales channels, or whether they are more costly. And for instance, with respect to advertising, I think the Commission points out that they are considerably more costly than having direct traffic from or generating direct traffic through search engine optimization from Google. And then with respect to how substantial the foreclosure effect is, so the Commission at least tried to quantify the foreclosure rates for the national markets on which this happens. And of course, then the question is, what is the right foreclosure or the threshold for finding substantial foreclosure? And I think that is an important factual question and economic question where I think people might also disagree. And then I think a second point that I would like to highlight is your point on the counterfactual analysis. And what is interesting here is that the General Court entrenches the long-standing capability standard as a standard of proof under Article 102. So it suggests it's not necessary that the Commission shows actual or likely anti-competitive foreclosure, but just that the conduct is capable of foreclosing competitors. And then the General Court makes the interesting point that requiring the Commission to carry out a counterfactual analysis, so to show causality rather than just correlation, would amount to requiring it to show actual foreclosure effects. So I think there might be a relationship between the standard of proof and the extent to which we might need a counterfactual analysis. Let me just pinpoint one point on market definition. So I think you raise a number of interesting questions about market definition. A major difficulty here was for the Commission that there was no possibility to carry out the classical hypothetical monopolist test because there's no market price. And the Commission acknowledged this. And I wonder how you would then suggest we should assess a substitution in this non-price markets. And at least when it comes to Google, its own perception was that comparison shopping websites are close substitutes and closer substitutes than merchants, online merchants websites. So for instance, it allowed online merchants to take part in its Google shopping unit, but not necessarily competing comparison shopping websites, which might suggest, at least according to the Commission, that there is a perception of substitution. And just to finish here, and maybe Damien will also come back to this. So the General Court also makes a very odd point about the need of an as efficient competitor test. And it suggests that there is no need for the Commission to carry out a as efficient competitor test for non-price abuses. And I think that raises a number of important questions because again, it creates some form of a differential treatment of conduct that might have actually the same anti-competitive effects. And perhaps we can also elaborate on this further down in our discussion.
Thanks, Elias. Damien.
Yeah, so coming last, I mean, a lot of the things I could have said have been covered already, so I'll be rather brief. I think what is quite interesting when you look at the effects analysis is the contrast with the Intel decision of the General Court. Now, you know, in fact, these decisions have been taken by different chambers, so different judges. I think, you know, with 56 judges, when you appeal a Commission decision at the General Court, you never know what you get, right? You can have you know, Premier League players at the helm or people playing in championship. So I'm not going to judge on the quality of the players here, but what I want to say is that it's interesting to see two judgments coming from the same court with very different mood, right? I mean, if you look at Intel, it's a pretty harsh rebuttal of the Commission decision. And it's very analytical, very granular, going into the nitty-gritty of the as efficient competitor test, right? I mean, you may say, of course, that the General Court did not have much of a choice because the case was on remand from the Court of Justice, and they had to sort of follow the legal standard and analysis of the court. But still, you have the impression, and in fact, you know, several clients asked me, so is there a change? I said, well, not really, because the change took place in 2017 with the Court of Justice judgment. But certainly, it sends a signal to the Commission that if the company comes up with a defense, they'd better look at it very carefully instead of reverting to the traditional formalistic approach saying, well, we need to look at the effects, but not really, because in any event, and so on and so forth. Now, if you look at this judgment, it is much more traditional in its approach, because what it does essentially in terms of legal standard, and I'm not going to comment on all the factual points that were made by Kayuve, but it essentially says the usual things, right? I mean, basically says it's enough to show a potential potential anti-competitive effect, which is a very low bar, by the way, right? I mean, you just need to show a potential competitive effect. I mean, lots of things can happen, right? And then there's no need for the Commission to identify actual exclusionary effect, which is a logical consequence. One point I wanted to mention is that Kai-Uwe said, well, there's nothing about prices. The truth of the matter is that the Commission doesn't have to look at prices and innovation. You don't need to show consumer harm. It's the standard case law of the court, right? So, you know, whether prices went up or down on innovation were up and down is actually irrelevant from a legal standpoint. I mean, as far as I'm concerned, I think these are relevant, highly relevant considerations, but the truth of the matter is that it is not. On the as efficient competitor test, where they seem to suggest that it's only for price-related abuses. It's an interesting point. I mean, I never thought, it's true that the AEC test, you know, has always been sort of considered in the context of pricing abuses, but does it really matter? It has no role to play in non-price related abuses. Certainly, it would have to be a different type of test. And then, of course, they seem to say, well, you know, you don't need to do a counterfactual analysis. That's a bit of a novel thing for me. I mean, certainly it's difficult in a case like this one. Whether you can completely do away with it is another question. So, you know, if you look at the standard of analysis, the Commission essentially repeats the sort of, you know, traditional case law. You have to do this, you don't have to do that. But you really see that the Commission is not really keen on pushing the Commission to go a little bit further. So very different from Intel in my view.
Thanks very much. Of course, the desire of the General Court to push the Commission to go further and to have more evidence and to make its cases ever more robust does fit with the issue that it took already 7 years at the Commission to judgment and it's a decision on this case, and another 4 to judgment at the General Court. So I guess it does fit with, you know, the heavier the burden you place in terms of bringing one of these cases, the longer it will tend to take to actually bring them, and the harder it will be to make them stick. During that whole case, there were 3 failed attempts at commitments as well. And since the end of the case, there's been several revisions to the remedies to the Google shopping case, with each attempt kind of failing to be effective. That does slightly go to the question of counterfactual as well. So I'm now going to bring us to this point about, you know, should antitrust really be the thing that we're using to deal with these sorts of issues? Certainly, the very large amount of time taken for this case and other cases like it, the lack of remedy effectiveness, those are 2 critical reasons why many people, including myself, have argued for the introduction of ex-ante pro-competition regulation for the largest digital platforms. And of course, I said earlier that this is now on the way with the EU Digital Markets Act, the most progressed. Well, actually, Germany already has its revision to the its own competition act, which is a form of regulation, and that's already in place. So in a way, they're very progressed. But in terms of formal regulation, the EU is the most progressed. That regulation, the DMA, will include a specific prohibition on self-preferencing in ranking services. The European Parliament actually is currently proposing, and there's negotiations ongoing, whether that restriction, that prohibition should run wider, and actually it should apply to a ban on self-preferencing, not only in ranking services, but also in other settings. Quite what other settings are slightly unclear. So clearly self-preferencing, it's covered under the new German Competition Act, likely to be included within the UK regulation when it comes. So coming back to the panel, do the panel agree that that this case helps to demonstrate why we need this sort of regulation, and more specifically, how do we feel about the proposed Digital Markets Act restriction on self-preferencing? Do we think that that is likely to be proportionate? I'll go to Damien first on this.
Thank you so much, Amelia. I think indeed that the Google shopping case played a role in, you know, the sort of initiative that led to the DMA. I say that led to the DMA because the DMA will be adopted. You know, I mean, some are still trying to engage in fear mongering and these sort of things, but they're essentially speaking to their own, they're essentially speaking to their own audience. I think the DMA is a reality. It will be wrapped up by Easter, and that's it, basically. Now, why did Google Shopping contribute to the DMA? Because Google Shopping, I think, encapsulates the reasons why, indeed, competition law is not necessarily the best tool to deal with these matters. I mean, first of all, there is the length. As you know, it's a case that has taken 7 years. And secondly, there is the sort of complexity. You know, it takes a lot of resources on the Commission side. You really need to have also, you know, very persistent complainants to survive the investigation. But also, at the end of these cases, the remedies very often are not restorative, right? Which means that assuming that Google did something wrong, there seems to be different opinion on this panel on that, right? If the company has done something wrong, has foreclosed competitors, well, then a 2 billion plus fine is very cheap, very, very cheap. Because for a decade, you engage in anti-competitive behavior and you've got a fine, and the remedy is not restorative, which is in the sense that the remedy is very often forward-looking. So you can basically get away with what you've done. So I think these are the main reasons why there was a growing consensus among, you know, experts that competition law was not the right thing to do. I must also make a point here, because I think it's very relevant to the discussions we've had and the comments that were made by Cayuve, is that sometimes I'm asking myself whether the effect-based analysis did not kill competition law as a relevant tool. I was very much in favor of it. And, you know, when there were discussions about the guidance paper, I wrote extensively about it, and I really supported it because I thought that, you know, the case law in some areas, or the Commission policies in some areas, like, you know, rebates and more generally price-related abuses, was nonsensical. But at the same time, if you really want to do that sort of analysis seriously, it takes such an amount of time and resources that you make the tool irrelevant, right? Especially if you operate at the glacial pace of the European Commission. Some of the competition authorities in the member states go faster. I think it's because they're keener and have more resources. But, you know, anything that lasts longer than 3 or 4 years produce a decision which is essentially historical in nature, right? Now, the DMA, indeed, there is, I think, you know, it is often said DMA is a completely different animal, in my view. And comparison with competition law are not relevant. I mean, it's a regulation, right? And voluntarily, the Commission proposal does not relate to competition law concepts such as, you know, market definition, dominance, and that sort of thing. It's a different kind of animal. There is a provision about self-preferencing, as you say, you know, will it be only for ranking? Will it be for ranking plus other types of settings? We will see. But at the end of the day, I believe that it's an important obligation. And the question will be whether it's proportionate or not. We will see what is decided, because obviously you will have litigation. Let's not think for a second that the DMA will not be heavily litigated. It will be heavily litigated. But personally, I think it's an important consideration. If you think about the App Store, for example, well, you know, if Apple entirely controls the App Store, so if they put their apps ahead of other apps, and there's no alternative distribution mechanism, what can you do about it, right? Perhaps the failure of the DMA is that it provides a uniform solutions to different business models and different situations. That's, in my view, the weakness of the DMA. But a prohibition of self-preferencing is, in my view, a positive consideration. Yeah, so let me leave it here.
Thanks. And just as a little advert, which I know that Damien is very aware of, but there is a very good interim report on mobile ecosystems by the Competition and Markets Authority, which looks exactly at that question of the power that Google and Apple have over their app stores, and the potential. One of the issues looked at is the potential for self-preferencing in that context. Kove, if I turn to you now.
Yeah, let me kind of, I think I have a slightly different view of on this, although I do think in some situations it's actually important to take things into regulation and take them out of competition policy. I think a really good historical example for that have been the payment card systems. That's actually something where I think it was fairly complex. The case-by-case intervention actually even led to distortions in some situations. But there was kind of just one really overriding fact, which were very large supernormal profits. And so that's kind of the thing where you kind of know if you're taking it into regulation and regulating the price in one way or another, that seems to be a better solution than trying to get at excessive pricing through competition policy. Now, I think it's kind of moot asking the question of whether we should be regulating this or not. My view is that kind of in all of these cases that I've seen that have taken a very long time, there were very serious doubts whether there was really a material distortion to competition, and that's why it took so long. I remember one bundling case that took 8 years. The complainant was still happily in the market, and there was a commitment decision, so I did write a final negative advice on that. But I've seen other cases that go rounds and rounds and rounds because someone believes there must be something wrong, and they take many, many years. I think the problem we have with the self-preferencing is, and that's kind of where I think whether it's rankings or not plays a big role. In kind of the German competition law, it's not rankings, for example, is the problem that what exactly could be self-preferencing when you're doing something for yourself is absolutely unclear. When I've started to think about thinking about what different companies might be doing, and that could be considered self-preferencing, it becomes virtually undefined. And the question, for example, in something like the DMA is going to become, how do I know that I'm actually complying with the law? And actually all of the problems that you're going to have with remedies in the current Google case, you're going to have afterwards in the DMA and discussions of whether the behavior is compliant or not. And you might have fines and so on and so forth, but in the end, the company again has to do something. And again, you have to ask the question, are they complying or not? What my second problem is, and I think it's a major problem, Damien saying, well, the main problem is proportionality. Well, proportionality is exactly what's at issue, but it's also kind of at issue in these competition cases, and that's the reason why they've lasted so long. We know a lot of things that look like self-preferencing behavior are actually pro-competitive, don't have major foreclosure effects. Therefore, we want them in terms if we're coming at this from the competition point of view. And the question is really kind of what are going to be the criteria where we have kind of the cutoffs. And so I'm worried about this because I don't see the conflicts going away from it, because of the lack of definition of what exactly self-preferencing is and what exactly of the effects of self-preferencing one actually wants to prevent. And that's even worse in the DMA, because we now have to interpret completely new principles that, you know, what contestability exactly means isn't necessarily clear. And with fairness, we've had historical problems as well. So I think we're buying into a whole bunch of new problems that are not really resolving the question that we want to have behavior that is spurring innovation enhanced, while behavior that is against that not enhanced. And I think at the moment we're creating rules that are not doing that. I acknowledge that it's very difficult to create them, but that's why I think kind of a more careful approach to the evidence in the antitrust cases that we're doing is actually quite important. And let me just kind of give one example of you know, it may sound ridiculous, but I'm just making it to ask the question, how do you actually decide what's self-preferencing or not? Suppose you have a supermarket that is a local monopoly, and they have the audacity of introducing an own brand of milk. And all the milk producers say, that's really terrible. They're filling up these shelves with their own branded milk. And it's terrible because we're losing milk sales. Is that anti-competitive self-preferencing? Or wouldn't we say, kind of in the situation that we know, own brands are really reducing the prices that everybody is facing and have had a very pro-competitive effect? It's a ridiculous example in a sense, but the question is, where do we move over to those types of ridiculous examples, and where's the boundary? And I don't think at the moment that the DMA is actually resolving that. If we're limiting things to rankings, I think that's less concerning on that side, but it doesn't resolve the question because we have these rules in Germany. We're going to get the rules in the UK. So we're going to have to deal with this question. And so that distinction between behavior that has good impact and bad impact will stay with us, whether we're doing it under antitrust law or not. And so I think it's an illusion to think that regulation on this is going to be the way out.
Thanks, Kove. Very often people do raise this supermarket example. I think in the milk case, because milk isn't particularly branded anyway, most milk producers will probably be keen to sell their milk. They care mainly about the price. But I also think that we usually don't worry about supermarkets because at least in most jurisdictions, they aren't monopolies. There is competition between them. And I think we feel rather differently here because these firms do have entrenched market power. And indeed, to fall under the Digital Markets Act, you have to have an entrenched market position. So I just say that on that comparison, which does come up all the time. I do think your point about the trade-off about proportionality and the importance of proportionality, and then Damian's point about yes, but there's a trade-off between that and actually achieving anything, and speed is a really interesting one. You're right that there is proportionality within the DMA. I think the way it works is that the burden is essentially shifted, so that in the DMA, effectively firms would need to show that an obligation was disproportionate in order to not have to put it in place, rather than under competition law, where the competition authority would need to show it was proportionate to bring a case. So I think it's about burden shifting in between the two environments to some extent. But Elias, your views on this in this area?
Let me just say one word about the supermarket example. So I would tend to agree with Emilia that the difference very often is market power, significant market power, and the impact then of the self-preferencing or category management agreements. And I think if you look at the vertical guidelines under Article 101, they also for certain category management restraints, they suggest that there might be anti-competitive effects, although they in general are pro-competitive. Then let me just say something about the DMA. So in general, I think I tend to agree with Damien that it is an important progress, but what Google Shopping actually shows that there is also a source of inconsistencies. And I think one relates to what Kai-Uwe said, that we don't necessarily know what self-preferencing means under Article 102. So does it require 2 conduct elements or only 1? And the DMA, for instance, suggests that 1 conduct element, namely just giving preferential ranking, is sufficient for there to be a violation of the DMA. And this might lead to inconsistencies in terms of the treatment of the very same conduct under Article 102 and the DMA, depending on whether the firm at issue is a gatekeeper firm. The second, I think, also source of inconsistencies is that the DMA to some extent replicates what Google Shopping suggests, that you do not need an as efficient competitor test, or you do not have to look at the efficiency of foreclosed drivers for non-price conduct, because the DMA mostly covers exclusionary non-price conducts and does not necessarily address rebates, predatory pricing, margin squeeze like abuses. And I think that is again to some extent replicating what Kai-Uwe suggested, namely that we treat similar conduct with similar effect, or conduct with similar effects differently depending on whether it's non-price or price conduct. And then I would also tend to agree with Kai-Uwe that one question is to what extent the rules under the DMA are really so self-executing, executing as one would assume it, because I think there might be a case that self-preferencing in the end also under the DMA would need some effects-based analysis for the Commission to bring a successful action. But I think that is something to be seen. A last point that I also wonder about is to what extent that DMA might actually have reverse spillovers on Article 102 case law. So to what extent we will move away under Article 102 also from the more effects-based approach, for instance, with respect to also pricing conduct, because to some extent, if you look at Intel, the alleged abuse took place in 2002. Now we are in 2022, so it took almost 20 years to have a judgment, final judgment on this case. And this is also just illustrative of the time impact that the more economic approach had on antitrust analysis with respect to pricing abuses. And I think I will close on this point.
Thank you very much. Well, we've actually had lots and lots of questions. So I think we're going to spend the rest of this session, so 10 minutes we have at the end, trying to answer some of these questions. I'm going to start with 2 questions, which I'm actually going to ask, I think, to Elias and Damien, and not to Kai-Uwe in the first instance, because I'm pretty sure he's going to just agree with the questioners, but he can come in if he doesn't agree. It's both Pratham Mishra and Agapi Kasimati have similar questions. Pratham says, is there a potential disincentive to enter, innovate, grow, and grow for future disruptive and growing digital platforms which are vertically integrated as a result of this decision? So are firms who want to enter and be exciting and new, are they actually going to be nervous of coming in because they might be hit by similar sorts of decisions? I think that's what that question is. And then Agapi says, how disruptive is this standalone abusive judgment of self-preferencing for other markets other than shopping? Is there any evidence emerging that it's impacted judgments in other cases involving other big tech in particular? Anyone want to answer that question?
I can say a few words about it. Yeah. I mean, I think on the first point, you know, these are you know, difficult questions. I mean, will this judgment have an impact on innovation? who knows, to be honest, right? I mean, all arguments about innovations are complex because innovation will not either start or stop tomorrow. These are things that happen in the long run. Now, let's think about it, right? I mean, one of the tricks of those opposed to the DMA is to say it will kill innovation and, you know, small companies will be disincentivized to invest. Well, there's a long way between, you know, innovating and becoming dominant or being designated as a gatekeeper. So I really don't think for a second that this sort of, I mean, this judgment of the DMA will discourage anyone to innovate. It might just constrain big tech. But as far as the new entrants are concerned, to the contrary, I think that it will stimulate them. What was the second question again? I know I wanted to say something about it, but I just lost it.
Well, it was really, are we seeing lots of standalone self-preference cases elsewhere?
Yes, I think so, because look, I mean, self-preferencing, of course, is a concept that can be used in many different ways, right? So, for example, if you look at the criticism that has been made against Google in ad tech, well, you know, this comes as a form of self-preferencing, right? There's a decision of the French Competition Authority, which, if you read between the lines, is essentially a decision about self-preferencing. So, indeed, I mean, I think that this is a concept that will pop up regularly in decisions, perhaps of the Commission, but certainly at the member state level. As to the point that was made by Elias, that there could be a contamination of competition law by the DMA, I don't think so, because it is so clear that it's a distinct instrument. I know that CCIA has funded a paper to make that point, but I'm not convinced at all.
Thank you. Kayove, you can answer that question, but I'm going to throw in another question for you as well.
Okay.
It's to you from Jose Daniel Vargas. He was interested in your point about the lack of data analysis by the Commission. And he was interested in why you thought that data wasn't collected, i.e., was it because the Commission didn't have enough time or just do enough work? Or was it because they didn't ask the right people? Or was it because the data was kind of inherently unavailable? And I guess he doesn't explain why he's asking that question, but I guess if the data is inherently unavailable, it raises some big questions about whether you can ever bring these sorts of cases if you set too high a standard on data. So I don't know that question for you, and if you want to comment on the previous one.
Yeah. Well, let me first comment on the other side, because I do think that the self-preferencing issues, also the DMA and others, are of concern, of quite a bit of concern of firms who you wouldn't think of the narrow big tech, but who are still concerned and kind of worried about what they're doing. I think kind of this idea of there's a really small firm that's now worried, should I ever have an innovation and come into the market because I might get big and fall under this? That's nonsensical. But I think a lot of the innovation that has impactful in these markets are actually relatively large firms going into new activities. And the way that they're actually facilitating the entry is combining it with the current activities and effectively self-preferencing them through that. And that goes beyond kind of GAFAM and the big tech. And I think we're already seeing companies seeking advice because they're very uncertain and are spending a lot of resources and thinking about their business models and what they need to do, which is of course taking time away from other things that they might be doing. So I think it has an impact, and it has a non-negligible impact. The second issue that I think is important, and where I have to disagree with Emilia and Elias, but also speaks to this question, which is this thing, well, but this is only about those firms who have really market power, and then, it's a completely different thing. The issue is very often, and that was the issue in the Google shopping case, is the market power that's actually there relevant for the ability to distort competition in the market? And a lot of the activities of these firms, that actually isn't, right? And so, that's the, essential question, and I don't want to come even down on one side or the other, but that's the essential question also in the Google Shopping case. Was it actually the case that the market power in general search would lead to effective reduced competition where it was relevant in the market? And I think that becomes a question that's not even asked anymore because of the assumption of market power, even if the linkage to the behavior isn't quite there. And so you came to the last point, kind of just remind me of that question, which was about, remind me the last question that you.
Oh, it was essentially, did the commission not do enough work, or was the data kind of inherently not there?
So I think there are a lot of ways of generating data these days. So a lot of this depends on consumer behavior, and I think these days we have very good methods of asking consumers. So we could find out a lot more about search behavior than there is. I don't want to judge what was done. I think there's also data there that was interpreted in certain ways, and a view that maybe more was not needed, or it would be too much effort, et cetera, et cetera. I'm not sure. I mean, it's a question of thinking about what kind of data do you need in a targeted way to actually answer the question, and systematically going through and kind of asking, what do I actually need to test for? And so I don't think I should say anything more.
Okay. I'm going to chuck in one more question, and then I'm going to ask everybody to just, because we're almost out of time, to either comment on that question or just say anything they wish to tie up. The questions, well, actually, it's two questions. One is Matt Cherry. He has said, in terms of regulatory approach and the concerns about kind of fixed principles, etc., do we think that the UK approach of firm-specific codes of practice is better, or does it address some of those concerns? Does it raise new concerns? And Bruce Lyons from UEA has said, actually, we've criticised the General Court decision for a failure to set out coherent underlying principles and also the variable quality of judges. But does the proposed solution, so regulation, actually address these problems? So any comments on either of those linked questions? Elias, maybe I'll ask you to start.
Yeah, on the more tailored approach under the SMS regime, the proposed UK regime. So if I understand the proposal correctly, now there's still a disagreement to what extent there are certain principles that will apply to SMS platforms across the board, and then the role of the more tailored rules or the code of conduct. And so to my understanding, it's not entirely clear whether self-preferencing then will be prohibited for SMS platforms across the board, or it will be part of the more tailor-made bespoke code of conduct. And then with respect to Bruce's question, I think that's something difficult to address, because it's not entirely clear to what extent the DMA, for instance, really provides a principled framework to determine what self-preferencing is, and also does not really, we don't really know how far the Commission then would have to go in order to enforce, let's say, Article 6, 1D. So does it have to provide any specific evidence for some form of foreclosure effect, or can it just apply it as a per se rule? I think that's something to be seen. That would be my comment.
Okay, thank you very much. I'm afraid I'm actually very rudely not going to allow Kaive and Damien their chance to answer the question, because we really are out of time. But I hope that everyone will agree that this has been a very rewarding and useful conversation. I think it's you've heard a lot of different perspectives, but actually really quite a lot of agreement as well. I think this is going to be a really important judgment that people are going to keep coming back to. I suspect we may well, I don't know if, do we know if there's going to be an appeal? To the east. There. Okay, so there's liable to be another judgment in time. So maybe we can have that conversation again when that one comes out. But in the meantime, thank you very, very much for joining us, everybody, and thanks very much to our panelists. Goodbye.
Thank you so much, Amelia. Bye.
Thank you. Bye.